Good morning and welcome to the Heritage Foundation. I'm Elizabeth Slattery. I'm a legal fellow here in the Meese Center. So in the next month, the Supreme Court will hear 3 cases involving First Amendment free speech claims. The first case, Janus, involves public employees who opt out of union membership but are nevertheless forced to pay a fee for costs associated with collective bargaining. Are they free riders or are they compelled riders? This is the court's second time looking at this very issue. In its 2015 term, the court divided evenly in the Friedrichs case after Justice Scalia passed away. The second case, Minnesota Voters Alliance, involves limits on passive political speech at the polls. While states have a legitimate interest in preventing intimidation and violence at the polls, can they ban hats, t-shirts, and other items that are deemed too political, such as a "Don't Tread on Me" t-shirt? And finally, the third case, National Institute of Family and Life Advocates, challenges California's attempt to force life-affirming pregnancy centers to advertise the state's free abortion program. The relevant law has so many exemptions that these centers are just about the only medical facilities in the state that have to post these pro-abortion notices. So to discuss these 3 cases, we're fortunate to have with us today attorneys who are part of the legal teams for each case. They will provide insights about the cases and how the arguments may unfold at the Supreme Court. So first up, we'll hear from Jacob Hubert. He is the Director of Litigation at the Liberty Justice Center in Chicago, Illinois, where he litigates cases to protect economic liberty, the First Amendment, and other constitutional rights. Jacob is one of the attorneys representing Mark Janus in the government union case. Jacob has also challenged anti-competitive regulations targeting food trucks, ride-sharing, and Airbnb. He's a graduate of Grove City College and the University of Chicago Law School. After law school, he clerked for Judge Deborah Cook of the Sixth Circuit. And then we'll hear from Todd Graziano, who is a senior fellow and the executive director of the Pacific Legal Foundation's DC office. PLF represents Minnesota Voters Alliance in the political t-shirt case. Todd is a frequent commentator in print, radio, and on TV. He served a 6-year term on the U.S. Commission on Civil Rights, and he previously worked here at Heritage, where he was my boss for 5 years. So welcome back. He also spent time in the Office of Legal Counsel at the U.S. Department of Justice and as a chief subcommittee counsel in the U.S. House of Representatives. Todd is a graduate of the University of West Virginia and the University of Chicago Law School. He clerked for Fifth Circuit Judge Edith Jones. And last but not least, we'll hear from Jordan Lawrence, who serves as senior counsel with Alliance Defending Freedom. He's one of the attorneys representing the pro-life pregnancy centers from California. Jordan's work encompasses a broad range of litigation with a primary focus on defending the First Amendment freedoms of public university students and professors. Jordan argued before the Supreme Court in Board of Regents versus Southworth, challenging the university forcing unwilling students to contribute to campus activist groups. He is a graduate of Stanford University and the University of Minnesota Law School. So with that, please join me in welcoming our panelists, and we'll hear first from Jacob.
Can the government force its employees to give money to a union just to keep their jobs? That's the question the Supreme Court will answer in Janus versus AFSCME, which is a First Amendment case in which the organization that I work for, the Liberty Justice Center, is representing the petitioner, together with attorneys from the National Right to Work Legal Defense Foundation. Our client is Mark Janus. He's a man who works as a child support specialist for the state of Illinois. When he started doing his job about 10 years ago, he noticed that fees were coming out of every paycheck and going to a union, AFSCME Council 31, even though he wasn't a union member and he didn't want to have anything to do with this particular union. And the reason Illinois could take that money out of his check was because it has a law on the books that says that the state can enter into collective bargaining agreements with unions where they will take money from every worker, regardless of whether the worker is a member of a union. And in fact, there are 22 states across the country that have laws like this on the books. And as a result of those laws, there are at least 5 million government workers across the country who have to give money out of every paycheck to a union, whether they want to or not. So our case challenges these laws. We argue that they violate the First Amendment because they violate the right to choose for yourself what political speech you will and won't support, and they violate the right to choose what groups you will and won't associate with. We lost in the lower courts because current Supreme Court precedent is against us. About 40 years ago, in a case called Abood versus Detroit Board of Education, the Supreme Court said that this practice was okay. It said you can't make people give money to certain union political activities, contributions to candidates, other things we might call electioneering, but you can make them pay the union for their proportionate share of the union's cost of bargaining on their behalf. How did the Supreme Court reach that result in Abood? Well, normally, in a First Amendment case involving forced support for speech or forced association, the courts would apply strict scrutiny, which is the highest form of First Amendment scrutiny, or what they call exacting scrutiny, which is also pretty rigorous. And under those standards, the government would have to show, at a minimum, that its infringement on First Amendment rights serves a compelling governmental interest, and there's no other way the government could serve that interest that would infringe on people's rights less. And so you'd think that if that's the rule, then in Abood, the Supreme Court would have made the government show that making people pay union fees serves a compelling governmental interest, and that there's no other way the government could serve that interest that wouldn't violate workers' rights as much. But the court didn't make the government show that in Abood. In fact, it didn't talk about the usual First Amendment analysis at all. It just kind of skipped it. And instead, it just said that it's okay to make workers pay for their share of the cost of the union's bargaining, because otherwise they might become free riders. They might get the benefits of union representation without paying for it. And the court said this relates to the government's interest in having labor peace. The idea there is the government has an interest in dealing with one union to represent everybody in a group of workers, and so to serve that interest, it can make everybody pay to fund what that union does. And that was about it as far as that analysis. And then the court said, but you can't make these workers pay for the stuff that's really political, like the electioneering type activity. The court said association for political purposes is at the heart of the First Amendment, and recognized that you can virtually never force somebody to pay for somebody else's politics like that. And so, as a result, we have this scheme in 22 states where workers are forced to either pay full union dues, if they're a union member, or pay what they call an agency fee, which is slightly less, typically, than full union dues. So, of course, in our case, we argued that Abood was wrongly decided and should be overturned. There's lots of problems with the Abood decision, and so I can't cover them all, but I'll hit a couple of key reasons why Abood was wrong. One reason is because it doesn't actually protect workers from paying for unions' political speech. And one reason why is because everything that a public sector union does is inherently political. When a union bargains with the government, it tells the government things like how much it should pay workers, what benefits it should provide, how it should run its programs. And of course, if anybody else talks to the government about those subjects, everybody recognizes that as quintessential political speech. When anybody else does that, we call it lobbying. So if a government worker is forced to give any money at all to a public sector union, particularly to fund collective bargaining, then that worker is being forced to pay for somebody else's political advocacy. And again, that's something the First Amendment virtually never allows. Another key problem with Abood is this free rider justification. It's not actually true that everybody benefits from what the union does. Some workers would prefer to represent themselves in negotiating with the government. They think, if you're an above average worker, you might prefer to be judged based on your individual merit instead of being lumped in with everybody else. And so if that's the case, then you consider the union's representation to be a harm. And then you're harmed again because you have to pay for it on top of that. So these people aren't free riders, they're just injured by the union. And that could also be true if your political ideas differ from what the union advocates for. For example, our client, Mark Janus, objects to the things that the union he's forced to fund has advocated for and advocates for now. Of course, Illinois is a terrible fiscal and economic mess, deeply in debt, and so he thinks it's wrong for his union to be advocating for billions more in government spending and advocating for tax increases to pay for that. And yet he's forced to fund this advocacy. The free rider argument just assumes that every worker only cares about his own narrow pecuniary self-interest and that money matters most to everybody. But of course that's not true. Lots of people care about their neighbors and their communities and their state's economy, and so they might not want more money for themselves all the time if they think it's going to put an unfair burden on other people. And under the First Amendment, we get to decide for ourselves what we value most and how we order our preferences with respect to policy. But the unions just presume to decide for everybody what should be most important to them and then make them pay for that. And of course, that's wrong. There are reasons to be optimistic. The court is prepared to overrule Abood in our case. A few years ago, in a case called Harris versus Quinn, a majority of Supreme Court justices joined in an opinion that essentially eviscerated Abood's reasoning, pointed out the problems I've mentioned among a number of others. And then, of course, as Elizabeth mentioned, in 2016, the court heard arguments in the Friedrichs case and then had a 4-4 tie vote after an argument in which people thought the court was going to rule in workers' favor. And so now, of course, we don't have 8 members anymore. We're now back up to 9, so presumably there won't be a tie vote. And so we're hopeful that the Supreme Court will restore every worker's right to choose for himself or herself what political groups they will and won't support with their money. And we're hopeful the court will say clearly that when you take a government job, you don't have to check your First Amendment rights at the door. Thank you.
Thank you. Todd?
Good job. Well done.
Well, I want to especially thank my former Heritage colleagues for putting on a great program and asking me back to participate. And I'm glad to be under your direction now, Elizabeth. Mm-hmm. Pacific Legal Foundation represents the Minnesota Voters Alliance and 2 of its officers who are challenging to overturn an unconstitutional Minnesota law that bans the wearing of any button, insignia, or T-shirt with such political insignia at the polling place. Now, this statute is much broader than just prohibiting messages about the candidates or the issues. In fact, its breathtaking scope is the principal reason that it's unconstitutional. I'm going to return to the legal standard in a couple of minutes, but first let's reflect on the extent to which the multi-billion-dollar apparel industry caters to all of our desires to express ourselves in our clothing. We often wear sweatshirts with our college logos on game day or especially after a victory. We wear T-shirts with thousands of messages, many of which someone would consider political. And we also wear a variety of other insignia that recognizes our views. So just so you don't think that I'm reading the statute broader than it is, one of the instructions that poll workers received in Minnesota about the law was that it prohibits wearing clothing or buttons, quote, promoting a group with recognizable political views such as the Tea Party or MoveOn.org and so on. Well, we wear clothes, of course, to express a variety of views, not just about the candidates, but let me talk about another category. Sometimes we even wear clothes that express ourselves, and we don't even care if other people understand the message. My former colleagues at the Legal Center here understood that on some days I would wear particular ties to indicate a particular mood, like the one I have on right now. And I didn't really care if anyone else understood them. I will cue the monitor. Yes, on the side monitors is a selfie that my daughter and her boyfriend took on Election Day 2016, and they then tweeted this picture out. Now, for those of you who can't see this screen, they're both wearing black t-shirts with the initials SMOD. Partially obscured underneath that is 2016. Now, the fact that they tweeted this out and they wore it with their I Just Voted sticker signifies that it was important to them, but they weren't trying to intimidate any of the voters at the poll because they knew that most people didn't know what SMOD meant, and those who did would probably chuckle. Well, for those who don't know, SMOD stood for Sweet Meteor of Death, who was a fictitious presidential candidate who promised to destroy all sentient life on Earth. Thankfully, we now know SMOD is just another lying politician. My final example, though, is that I gave a tie with dolphins on it to my dad to wear when he testified as an expert witness, and the lawyers would challenge his qualifications. He thought those lawyers were sharks, and he was amused by the fact that pods of dolphins can chase away sharks. Now, he doesn't really think that his tie was intimidating the council, but it just made him feel better. It made him feel better to privately be communicating that message. Which brings me to the facts of our case. Running up to the 2010 election, the Minnesota Voters Alliance printed t-shirts with various messages, including one with the word liberty, which obviously has a political meaning. Now, our client, the president of the Minnesota Voters Alliance, Andy Selick, was twice prevented from voting at his polling place with his Tea Party shirt that had the Gadsden flag on it. The Gadsden flag is a Revolutionary War era drawing of a coiled snake with the words, "Don't tread on me," and that's one of the symbols in my tie. On his third attempt, he was allowed to vote, but the poll workers said they were taking down his name, which they would pass on to law enforcement officers for possible prosecution or criminal or civil fines. Now, in the 7 years of litigation that followed, the state defended its ban on such horrible, scary, intimidating clothing on two bases. One is that it ensures peace and order at the polling place, and it would prevent intimidation and confusion. Now, the Supreme Court has, as Elizabeth noted, upheld restrictions on active campaigning or electioneering within 40 or 100 feet of polling places. It varies by state. But that involves active campaigning where you're actually confronting a voter. We do not contest or object in our lawsuit to any of the active campaigning bans. But it is clearly unnecessary to ban all political speech. By the way, every state also has separate laws that actually ban any conduct that's intimidating or fraudulent or disruptive. So if it was possible to silently intimidate someone with your clothing, that would already be prohibited, and you don't need a separate statute that bans all other kinds of speech. Now, the overbreadth doctrine under the First Amendment, I go back, the central issue in our case is whether the Minnesota statute is overbroad in suppressing a substantial amount of protected speech compared to the state's purported interest in protecting against dangerous speech. To use one very narrow example, the state might be able to ban classic fighting words on a t-shirt that objectively, would incite fights. But that's just a very tiny amount of the speech that the Minnesota statute forbids. Now, this overbreadth doctrine under the First Amendment allows people like our clients to not only raise the speech they bring, but also raise the type of speech that others want to bring. It's a great service to bring such an overbreadth challenge, and a number of state and federal laws have been struck down under it. So at this time, I'm going to point to my colleague in the second row, Wen Fa, and ask him to raise his hand. Wen is the principal architect of our overbreadth petition to the Supreme Court. And his petition was so effective that now, 7 years later, the state is trying to change its defense. So in its latest brief, it is trying to reinterpret the statute. I'm going to conclude with the 2 reasons why that's not going to work. First, the statute plainly does cover all political speech on T-shirts and not just a subset that's particularly dangerous. One of the other points that Wen made in his petition and in the current briefs is that the whole concept of what is political speech is so broad, and I should say politicized, that almost any message can be considered as political. If a U.S. Marines shirt promotes the military, which some say is political, private religious messages like Jesus saves or choose life are considered political. And that raises another concern with the statute, because even if a particular poll worker wants to apply it neutrally, a liberal poll worker who's assigned will probably view some messages as political, but think that messages about global warming are not. A conservative poll worker would think that certain environmental messages are political, or, you know, a Chick-fil-A. No, they would not think of Chick-fil-A. That would be the liberal. But others would not. So even if the poll workers are trying to apply this fairly, it will result in viewpoint discrimination and selective application. But the risk of actual conscious abuse and selective intimidation is even worse. And then my final reason why this state's latest gambit won't work is that they admitted during the litigation that there are especially broad applications of their law, and they can't take that back now. So I'll let you raise your hand if you think the following are political. Wearing a Minnesota Vikings sweatshirt. I see no, I see one hand, only one hand. An AFL-CIO t-shirt. About half. A Chamber of Commerce logo on a t-shirt. Only a few. The state admitted all 3 of those are political and would be banned at the polls, at least if the Minnesota Vikings was seeking, you know, a bond for a new stadium. Well, let me conclude with the most ridiculous argument that the state makes, that they must ban all Tea Party t-shirts and all AFL-CIO t-shirts to promote peace at the polls and prevent silent intimidation. The Supreme Court made clear in a Vietnam War era case that unfounded fears of disruption are not grounds for a speech or a clothing ban. In that case, it was an arm ban. And an unfounded fear that political clothing worn in the line by a voter will trigger some other voter is an equally insubstantial reason to ban all political speech at the polls. Thank you.
Jordan?
To remind you who I am, I'm Jordan Lawrence with Alliance Defending Freedom, and we've heard these 2 great presentations from Todd and Jacob. And ADF attorney, our CEO, Mike Ferris, will be arguing the NIFLA case, which stands for the National Institute of Family Life Advocates, in the next sitting in March, on March 20th, which challenges a California law requiring pro-life pregnancy centers to post pro-abortion messages. And I want to get into that in just a moment. But I do want to take just a few moments to talk about just why these are important, and that, you know, these cases sound pretty different, but I think that there is some link that I just want to start off to give as an overview. And that's this, is the Founding Fathers in the first Congress, when they did the First Amendment, understood these basic principles. The government operates by coercion. And sometimes we like that if they're stopping drunk drivers or people running red lights and things like that. It provides order. People that are cheating or whatever, defrauding folks, etc. But there is a human tendency to basically misuse this governmental power of coercion to either censor those who are opposing the prevailing orthodoxy at the current time, or by forcing people to basically assert their allegiance to the prevailing orthodoxy at the time. And the First Amendment is put in to basically say that Congress and now the states through the 14th Amendment may not misuse that inherent coercive power to government to punish dissenters, to force people to say the prevailing orthodoxy, because that changes over time. And we see examples of this here in these cases. So the Minnesota Voters Alliance case is just straight out censorship. The Janus case is compelled speech via funding. And the NIFLA case is just straight out compelled speech, forcing people to promote a message that they don't agree with. Now, what's the facts? This involves a California state law, and it's targeted against these pro-life pregnancy centers. They're all over the country, but the ones in California, there's many of them there since it's the largest state population. But basically what they do is this. These centers have a sole mission of encouraging expectant mothers to give their children life. And they do this by various means. There's two types of these centers. Some of them have medical licenses, so they can do some medical things like ultrasounds, for example. And some of them are unlicensed, and all they do is basically good works. They supply women resources like prenatal vitamins, diapers, baby clothes, and basically counseling and encouragement if they're in a difficult life situation, so they'll give life to their children. Well, the state of California views this as a problem that has to be fixed, and we'll talk about what this problem supposedly is. But let's talk about the solution and how unconstitutional it is. So the licensed facilities that basically do medical procedures like ultrasounds, and basically not more than that, they're not doing operations or anything like that, are forced to post this sign at their facilities. And I'll just read it to you. California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at, and then a phone number is given. So, to make this clear, these are pro-life centers dedicated to helping expectant mothers give life to their children, are forced to put up a sign that says, hey, do you realize you can get a state-funded abortion? Here, call this number and find out more information. So it's obviously highly offensive to them. Now, those are the medically licensed ones. The unlicensed facilities have to put up a different message, and that message is this facility is not licensed as a medical facility by the state of California and is no licensed medical provider who provides or directly supervises the provision of services. So the first thing that the women going to these pro-life centers learn is that it's not a medical facility, that there's something negative that has to be expressed. Then to add the problems with this, the state law requires both these signs to be in English and what the state of California calls threshold languages. So they do some demographic review, and if a certain demographic group that speaks a language different than English is hits a threshold, then you have to put the ads in those languages. So, for example, in San Diego, where some of these centers are, these threshold languages are English, Spanish, Arabic, Vietnamese, Tagalog, and Farsi. And in Los Angeles, it's English and 12 other additional languages. So you think if you want to have a bus ad or an ad on the internet that says, pregnant, need help, call this number, it's pretty lengthy with all the languages, and it basically makes it either impossible just from the physical size of these ads, or electronically on the internet, or just terribly expensive, so it effectively cuts off their ability to advertise at all. So we have challenged this law. A group of these pro-life centers, both licensed as medical facilities and ones that are unlicensed, they've lost the entire way up, and the Supreme Court is granted review in the case. And just one little bit of Supreme Court little statistical nerdish trivia. Maybe we'll see this on the SCOTUS podcast that Elizabeth does, is that statistically, there's about 8,000 cases appealed a year to the Supreme Court. They take about 80. They reverse about 2/3 of the time. It's been a pretty constant, consistent statistic. So if you want to amaze your friends at a party, say, hey, you know that case the Supreme Court just granted review? I predict they're going to reverse. And you're going to be right 2/3 of the time. I would just point out that we have all lost our cases at the lower court. So the fact that the Supreme Court is granted review, it doesn't guarantee a win, but it is a hopeful sign that, that we've been granted review in these cases. Now, what we have challenged in this case is that this is just flat out compelled speech, especially to the medically licensed facilities. To me, it is just shocking and just a raw display of governmental coercion for California to force pro-life pregnancy centers to say, hey, have you thought about getting an abortion? Or, you know, we just want to bring that to your mind. Here's how the information on how to get that. And it'll be at no cost to you. You know, check us out. You know, here's the phone number. That to me is just galling. These are also viewpoint and content-based discriminatory because they're targeting certain groups by a very gerrymandered. So the regular doctor's offices, a regular OBGYN does not have to post these signs. And they do it, and you can look at our briefs, and I won't take the time to explain it here, but basically the only places in California that have to do this are the pro-life pregnancy centers that give their services for free. And that, to me, is most shocking. Now, what is the government's justification for this? What they say is, the California said, well, the reason we have to do this is because these pro-life places are so deceptive and they just trick women into thinking they're abortion clinics. Now, there's no evidence to that. There's a bunch of assertions that were made by abortion rights supporters to the liberal California legislature, but there's basically no evidence to this. They're also arguing that this is commercial speech. But now, think about this. These are ideological opponents of abortion that are offering their services for free. That is not a commercial transaction, and yet that's what this state is arguing and what the lower courts justified this as regulation of commerce. Also, this could be, well, what about medical disclosure laws or something like this? If this were a law that said, hey, there's dangers in getting an ultrasound, here they are, we're going to disclose this so you can be a fully informed medical patient, maybe that would be justified. But here we have the state of California basically saying this. Even though you're at this place that doesn't offer any surgical procedures, let alone abortion, we want to post a sign to remind you of a surgical procedure you could have and then entice you with the fact that the state will pay for it. That has absolutely nothing to do with the normal types of governmental regulatory regulations that compel disclosures so that medical patients, for example, can be fully informed in their decisions. And I just want to end with this. One of the greatest decisions of the Supreme Court, and one is just all Americans can be proud of, was the West Virginia v. Barnett. When at the height of World War II, we're fighting the Nazis and the Axis powers, the Supreme Court saw the wisdom of the First Amendment to stop a West Virginia law in effect that forced unwilling people to say the Pledge of Allegiance. And they were viewed as, Nazi supporters or whatever. And all that cultural milieu, the Supreme Court nonetheless said the First Amendment protects the right of conscience against compelled speech. And they wrote this: if there is any fixed star in our constitutional constellation, It is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not occur to us now. Thank you.
So we're going to open it up for questions from the audience, but I wanted to pose one to the panel first. So Justice Kennedy, the perennial swing vote on the Supreme Court, he has a pretty strong record on First Amendment free speech issues. So how do you think he's going to approach each of these cases?
Well, I guess I'll go first. We know that Justice Kennedy has already heard this issue and has already cast a vote on this issue in a decision that resulted in a 4-4 tie. So, we can't presume that he'll necessarily think of this case the same way, or even what exactly that 4-4 split meant. But, there's reason for optimism there, and Justice Kennedy is pretty good on these First Amendment rights, and in his comments and oral argument in the Friedrichs case was very challenging to the other side of this issue. So, he seems to me like a strong supporter of First Amendment rights in this context.
As an advocate, I'm a little bit constrained trying to say what I think the justices will do in our case, except that I think Kennedy is not I think he is, as Eugene Volokh pointed out, one of the most free speech protective justices. And particularly in our case, where sometimes conservatives are upset about his free speech protection if they think, or some of his decisions, because they support personal autonomy. In our case, it's all about personal autonomy that has nothing to do with the state's interests. So I think he's not going to be. I'll be surprised, let's say, if he is fine with the Minnesota statute.
Justice Kennedy has been a good vote on freedom of speech, and I think he and many of the others will just, we will see in a month with the oral arguments, or a month from today, in the NIFLA case. But I think that the California law is such a shocking overreach and misuse of governmental power to compel speech that at least for the licensed medical facilities, I think we might be looking at every justice voting to strike it down. I mean, I'm hoping.
That would really be something. With that, we're going to open it up to questions from the audience. So please wait for the microphone, and then if you would state your name, and please keep it brief. We'll start here in the second row.
Hi, Wen Thaw. I'm a colleague of Todd's at the Pacific Legal Foundation. I just wanted to mention, I thought those were all excellent presentations. Just to mention one more thing about the Minnesota Voters Alliance case that distinguishes it from just a ban on campaign-related speech. And that's, the overbreadth doctrine is concerned a lot about the chilling effect. So it's easy enough, if you're a voter, to avoid wearing a shirt that said, vote for Trump or vote for Hillary. But if you were just wearing a shirt, if you had a shirt that said, say, Heritage Foundation or Federalist Society or AFL-CIO, I think it's very likely that you wouldn't go into the polling place wearing that shirt, even if you don't know whether that shirt would be prohibited or not, just because of the chilling effect of the regulation and the possibility that a poll worker might take your name down for prosecution.
Yeah, there were news stories in the last few elections with, poll workers who took issue with someone wearing a Massachusetts Institute of Technology, MIT, sweatshirt when MITT, Mitt Romney, was on the ballot. So you can see how, poll workers can get confused in addition to selectively enforcing these sorts of things.
I grew up in Minnesota. I actually voted at ballot places, and I cannot imagine, did not realize this law, and I just don't think I was so fragile that I would be influenced by those kind of shirts, or something like that.
You don't seem like a special snowflake to me.
Right.
Right here.
Ray LaJeunesse, National Right to Work Legal Defense Foundation. Great job, Jacob. You've commented, all of you, on Justice Kennedy. Justice Gorsuch hasn't voted on this issue. Can you give your thoughts as to where you think he's going to go? And what in his record supports that?
I don't think I can presume to say where he's going to go on this. I don't think there's been anything closely enough on point. And, you know, I know there have been cases where he's been supportive of First Amendment rights, but nothing super analogous to this that I know of. So I really don't feel like I can comment on that.
Todd, Jordan?
I mean, the one thing that I would point to is, and I, at this moment, cannot call to mind any of his Tenth Circuit opinions. But I do feel that in the other areas, that in his brief tenure, his other First Amendment cases, so I'm thinking of the ADF case from last spring, the Trinity Lutheran case, very strong decision there. And then his questioning that he gave on the compelled speech issue during the Masterpiece Cake Shop case. I realize that that's not a whole lot of data, but I think he sounds pretty good on the First Amendment.
I'm going to follow Jordan. I think we're going to win 9-0.
We certainly hope so. In the middle.
I think that's right. I would agree on the Minnesota. I think that that's really overbroad.
Gerald Chandler, two-part question about the California case, the NIFLA case.
Yes.
First, could you elaborate on the discussion of why abortion clinics shouldn't have to put up a sign that says you don't have to have an abortion, you can go to these family planning clinics? And second, could you elaborate on what the lower courts said that made you lose? The
way the exemption works, so they have this general law, you have to post all this stuff, all these things that I read. Then they exempt, they basically have a whole series of exemptions of various clinics and medical practices that if you're not primarily, I think it is OBGYN, you're exempt from this. But then also, if you participate in a different California program that basically you have to agree to either perform abortions or to refer women for abortions. And that if you do that, then you're exempt from this. So these pro-life places that are licensed facilities have an ideological objection that they're not going to refer a woman to an abortion. So therefore, surprise, the only people, the only institutions that this applies to are the ones that are have an ideological objection to abortion. And the other thing that one other thing that I just want to mention is that if California thinks that women are not informed enough, that they don't know that they can get state-funded abortions, there's all sorts of communication channels that the state can use to communicate that. And basically the only one that it does, so it's not like putting ads on buses and on the internet and stuff like this, or in newspapers. It's basically only requiring these pro-life places to do it, which to me shows the clear ideological viewpoint discriminatory targeting of it. And the reason we lost below was basically they said, the Ninth Circuit said that this was regulating a profession, that which is not a doctrine that the Supreme Court has recognized, that the government has the ability to regulate professions by requiring compelled speech. And they even though this is a clear content-based exclusion, where the Supreme Court, in another ADF case that we won a couple years ago, in the Town of Gilbert case, said any content-based exclusions always get strict scrutiny. The Ninth Circuit said, well, yeah, there's that Town of Gilbert case that the Supreme Court said, but we have Ninth Circuit precedent that gives us the government a more permissive standard, and that's what we're going to use. And I think that also might have been a reason why the Supreme Court took the case.
Other questions? In the back?
Hi, I'm Andrew Ham. I'm also not a lawyer for this question, so that may take some of it out. But could California just say, okay, well, everyone has to post the notice, whether you perform abortions, whether you participate in the program, everyone has to post a notice. And then does that then take away the
Well,
charter.
that might be a different situation, but that's clearly not what the law does. And so it's very, very gerrymandered as to who has to do this. We might face that in a different case, but we definitely do not have that situation here.
I'll just add from my civil rights background, if you have a discriminatory motive or animus or
Yes.
whatever, and let's say you you consciously segregate the schools, and there was a series of cases after Brown versus Board of Education, but then in some jurisdictions, they would do the same thing, but they would call it a neighborhood plan, or they would shut down in one case all the pools. You know, if we can't have segregated pools, and the Supreme Court saw the pattern there. So one, you can sometimes cure an unconstitutional viewpoint, based action with a neutral law, but once the animus or the discriminatory intent is clear, you still run some problems if that's what you're really trying to do through another means.
My name is Jack Geiss. I had a question for Mr. Hubert. Just, it's a narrow question, but say you have some people who are not a member of a union and they're negotiating on their own, and the state says, look, we're not exactly pro-union, but they can be very annoying. We're going to pay you less because you have no bargaining power. Is that okay? I mean, I'm just curious because that is a possibility, at least in the abstract.
Well, right now in these states where you have the mandatory fees, the union is by law the exclusive representative of all the workers, whether they are members or not, and that's not going to change if we prevail in this case. The union will still have to represent everybody, so you won't have people off representing themselves. You could switch to a system like that, under which it would be possible for people represented by the union to get one wage and people representing themselves or by another union or whatever get paid something else. That could happen, but the laws would have to change first. And I don't think the unions are going to push to change this legal arrangement because they like being everybody's exclusive representative, whether they get paid by everybody or not.
Any other questions?
My name is Bill O'Malley. On the NIFLA question case, the only time you mentioned religion was when you read to us from Barnett, the quote from the case that you
Right.
and anybody would support. Why aren't you mentioning religion? Doesn't that bring a special strength to a First Amendment right? Not that it would be the sole argument. I'm not suggesting that.
No, it's a great question. I was the main laboring oar at ADF to put together the cert petition. And we included both a challenge under a question presented under the Free Speech Clause and under the Free Exercise Clause. And when the Supreme Court granted review, they said, we're only going to hear the free speech question. So that's why you have not been hearing us, even though there's with many of the people involved at these pregnancy help centers, they're motivated by their religious beliefs to be pro-life. That's just not an issue the Supreme Court's going to concentrate on, so we've been basically focusing on freedom of speech.
Is that because they think they're going to solve that issue with the cake baking?
No, I don't know. I think it is frequent at the Supreme Court where the advocates will put in a cert petition several questions presented to get cover the whole range of particular constitutional provisions that will allow them to win. And sometimes the Supreme Court will say, yeah, we'll take all of those questions presented. And with some frequency, they'll say, nah, we're just going to narrow it down to this one. I'm not quite sure what their reasoning is, but so that's why we have this why we're emphasizing the compelled speech and the content and viewpoint discrimination nature of the law.
I think we have time for one more question. Any takers? Oh.
Mr. Lawrence, there are some states that place restrictions on abortion doctors. Jason Calvi with EWTN News Nightly. There are certain states that have restrictions on abortion doctors that they have to provide information to clients, for example, that a baby can feel pain. If you win this case at the Supreme Court, will those laws face challenges and will they possibly be invalidated?
We have had many questions. In fact, when I was writing the cert petition, I was having people say, well, what about all these informed consent laws that are the way you described them, that informing women about fetal development, et cetera? Are we not aren't we undermining those by winning this case? And I would say no, absolutely not. For this reason, is the informed consent laws are based on the fact that the women are going to undergo a surgical procedure. And just like, any kind of, not just an abortion, but any kind of surgical procedure, I think there's a governmental interest to make sure the patients about to undergo this are fully informed of the implications of what could happen, possible things that could go wrong, that sort of stuff. So I think all of that, the basis for an informed consent law for an abortion surgical procedure is very sound and is in the flow of all these other informed consent laws for other medical procedures. Here, and I said this before, but just to emphasize, if this were a law that said there's dangers to getting an ultrasound, we would probably have a weaker case. But that's not what they're saying. These women are not undergoing any type of surgical procedure or the only medical procedure the state's not requiring them to say anything about, an ultrasound. And they're in fact suggesting that they get a surgical procedure that they can't get at the place that they're at, the pro-life place. So this to me is like the antithesis of this. And to use that kind of informed consent, like they say, well, we require the abortion doctors to inform the women, so therefore we gotta, it's so illogical and such a non sequitur, I think it doesn't even fit here. And so therefore I don't think there's any undermining of those laws.
Well, with that, we've come to the end of our time, so please join me in thanking our panelists.